right back. Hold on. Okay. All right, guys. So this is my friend Jamie here, Odell from New York. So this last week we had kind of a slower week, right? So we started out in New Hampshire after spending the weekend or the holiday with a state representative out of New Hampshire and his family, which was awesome to be able to spend that time with a state representative. And and he was behind what we're doing. I mean, he wanted to learn more about it and actually invited Jessica and I to come up and spend the holiday with him and his family. And so it was awesome. And we had some really great discussions. And it just so happens that he's also one of the founders of Project Veritas, which is even better, right? So we spent 7 days with one of the founders of Project Veritas and sporting all of his gear now. And we had some great ideas on how to get this information out into a much larger scale. And so I'm looking forward to seeing what we'll be able to do together moving forward. But last week we did serve 2 counties within the state of New Hampshire. So we served Grafton County and we also served Belknap County in New Hampshire. And then we left New Hampshire, we came down into New York. And so yesterday we served Erie County, New York, which is Buffalo. And we tried to get back over to Rochester and serve Rochester, but we didn't. They wouldn't allow us to serve. So we did get one more service done here in the state of New York. And that was with Jamie here. So Jamie took on the first part of the service, the part that Jessica was doing before. Took on the first part. I took on the second. So we did get service done to the Buffalo area. So that in and of itself was 954,000 more people that we advocated for. Which is awesome. It's awesome, guys. But now we're stuck for the weekend. Don't really have anything else. So we're here and we want to come on because Jamie's got a story he wants to tell, and we've got some things that I think that we'll be able to talk about with regard to his story to help you guys understand better, what you guys are going through in relation to, his experience. Because, like I've said before, one thing that's extremely important for us to remember is that all tyrants are exactly the same. Even Saint Augustine of Assisi said that. He said, how incredibly alike are all the tyrants, but how gloriously different are each of the saints. Tyrants are all the same. They act the same way. And as a result, what most people fail to recognize is the fact that what is produced by a tyrant's tyranny is going to also be the same. And that's why everybody's stories are so similar with one another, is because the tactic of the tyrant remains the same. So, as Jamie gets in here, introduces himself, tells a little bit about his story, you guys are going to be able to say, wait a second, now that sounds an awful lot like what has happened to me. And that's because the tyrants are all the same. They act the same, they treat the same. And as a result, the product that is produced by their tyranny is the same. And that's why so many people have such a common story. And again, most people don't even realize it. Jessica talks about this often where she says, up until a year ago, I had no idea that this was happening to anybody else. I thought that it was one single rogue judge. No, this isn't one single rogue judge. This is a system with systemic issues where those that are in a position of leadership to administer the system is acting in an unlawful, tyrannical manner and what they're doing is treating people in like circumstances differently. That's what tyranny is. So, Jamie, introduce yourself, please.
How's it going, everyone? I'm Jamie Odell. I'm from Rochester, New York. I live in a town called Greece, New York. You guys could look it up. Greece is one of the biggest suburbs in New York State. And just like everyone else, I feel it's the most corrupt. And I mean, everyone I've talked to I've talked to people outside Rochester, just like he's saying. I always thought it was only in Monroe County that this was occurring. But the more I've talked to people in Chicago, I've talked to people in Florida. I've talked to people in Texas. Everyone's story seems to be the same. Just with different charges, accusations, family court, them taking their children, them giving them to the wrong parent. they'll give them, they'll have two people that are dating. They'll have the one that's abusive, the narcissist. Then you'll have the one that's not, and then one that's not is the one that has the kid taken away. They give them to the narcissist. And as we were speaking earlier today, it seems like because the judge, they're liars. They truly are. So they go along with the one that's lying because that's who they are. That's who they can, refer to as whatever, just understand. Where the other one that's innocent, you seem like you look crazy because you're over here speaking the truth. You're more, buoyant. You're more loud. You want to express how innocent you are, and then they want to just look at you like, oh, look at the way he's acting. He must be nuts. He must be crazy. No, you're innocent. I'm innocent. But the story it starts in December 2023. I don't even know how far I want to get into it, but it's such a long story because it seems like the more I find out, instead of being smart about it and keeping it to myself, I'd go out and I'd go to the court. They're doing this, they're doing that, when it was probably one of the dumbest things I could have done because just like in poker, you never show anyone your hand. So if you guys are going through something like this, remember that anything you have, keep it to yourself when needed. Don't even trust your own attorney. From what I've spent over 40 grand. I've had 4 paid attorneys, 5 public defenders. Not one who's helped me. I'm in a worse position than when I started. I was arrested back in 2023. Found out there was only, they were supposed to just remove me, they were telling me. But they didn't. They came to my house without a warrant. They handcuffed me, brought me to the station, booked me, arraigned me, all that fun stuff. The next day, went to get my property, did everything I was supposed to do. They arrested me again, and it just came to be a process. Every other couple months, arrest. Did I do anything illegal? No. It's just I kept on finding out more and more. I found out I had no charges, calling the DA's office. They're telling me, because I told them, my ex-girlfriend had a motive. She wanted me out of here. DA tells me on a recorded call, sorry, sir, there's nothing we could do. I go, what do you mean? They're like, we don't have anything down here for you on our eyes. You're never being arrested. What? So I started calling around, and then that's another thing too, record everything. So I started calling around, and all these sheriffs, cops, everyone. No, there's nothing here for you. Brought that to the judge's attention in court. 2 weeks later, the Greece police contacted my ex-girlfriend and told her to press or file a report against me, which she did. And one of the charges was a second-degree assault. She said in February 9th of 2021, I broke her finger while holding her daughter that wasn't born until December 27th, 2021. The judge dismissed that charge but kept the assault. Who knows why? And then it just was another thing after another thing after another thing. And I got indictments. We were looking at today where they're the DA's signature. I got like 5 different copies of the same one. The signatures are different. There's missing stamps. There's the 4-person signature is not there. My lawyer knew about all this. What did he do? Nothing. He hasn't done nothing for me. I've been doing like every day. I just sit at home. I'm looking at the computer. I find something else, and it just seems like, what did my lawyer do? Nothing. I've had to do everything on my own. I've had to look up everything, and that's what we were talking about today. I don't even think people honestly don't even need lawyers. With AI and the way everything's at the tip of your fingers nowadays, I think anyone honestly could do it themselves because who's going to fight harder for you besides yourself? But like I said, I don't want to get too much into this because I think what it is everyone wants to talk about how important their story is. And that's the way I always felt. And then when I hear other people, my story is the most important. My story is the most important. I started to think to myself, and just like we were talking today, it's not about each person's story. It's about like what? Like the fruit of the poisonous tree. Everyone's story is like an apple, and then you got, what were we saying? Like the tree would be like the
Fruit of the poisonous tree. Yeah.
Yeah.
So yeah. What he's getting at is that, once again, like I need everybody to understand that that a class action, right? Because that's what we're trying to, that's what we're trying to reach. You all know this. Class action is what we're trying to obtain. Because with a class action, that means that we can litigate all parties together in one single act. But that doesn't mean that we only get one shot. It means that if one of the petitioners overcomes their procedural situation, all petitioners in the same procedural situation overcomes theirs. This is extremely important. So, when you look at the situation, so Jamie here, he's got errors within an indictment. He did get an indictment. I would argue that it wasn't really an indictment because once again, the purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor. The purpose of that proceeding is to protect Jamie from the prosecutor, and yet the prosecutor denies Jamie the right to be able to be present to benefit from the proceeding that exists for his protection. We don't need any of that. But so when the prosecuting attorney who represents the accuser denies the accused the right to be present to confront the hearsay accusations against them in the proceeding that exists for their protection from the prosecutor, a crime was committed. It's called obstruction of justice, right? And this derives from Title 42, subsection 1981. Remember, Title 42 is a Civil Rights Act. But 1981, what it says specifically is that all persons within the jurisdiction of the United States shall have fair and equal benefits of all laws and all proceedings. The Fifth Amendment is a law of the United States, therefore it's absolutely protected by 1981. The grand jury is a proceeding created by the Fifth Amendment, therefore it's also protected by 1981. Therefore, all persons within the jurisdiction of the United States shall have fair and equal benefits of all laws and all proceedings. Let me ask, if you're not present in the grand jury to confront the hearsay accusations against you because the very person that proceeding is designed to protect you from is denying you your right to be present, are you benefiting from that proceeding? Absolutely not, right? That's called an abuse of process. An abuse of process is when one party abuses the process so that they can get advantageous leverage within the proceeding. So if they intentionally, right, or maliciously or purposefully prevent one party from participating in the proceeding that exists for the protection of the person that you're denying the right to be present, that is absolutely an abuse of process. It's also an unequal application of the law because there's two parties. There's a complainant, there's an accuser, and there's an accused. There's a moving party and a respondent. There's a victim and a defendant, right? There's two parties in every cause. When the government agent, being a prosecuting attorney, permits his client, the accuser, the right to be present to benefit from that proceeding, but then at the same time denies the opposing party, the defendant, the right to be present to benefit from that proceeding, once again, that's an unequal application of law. That is a person in a position of authority that is treating two people in a like circumstance differently and denying someone the right to be present. So there's a few issues here. We all know there's the issue of the outright absence of the indictment by a grand jury. Felony information. People in Oklahoma are being charged by felony information. People in Pennsylvania charged by felony information. People in Connecticut, Michigan, North Dakota, Washington, those people are being charged by felony information. And felony information is an oxymoron because you can't have felony information because a felony requires an indictment by a grand jury because a felony is an infamous crime. And the Fifth Amendment says that no person shall be held to answer for an infamous crime without an indictment by a grand jury. So there is the issue of those that are being denied facially the right that's codified and enumerated within the Constitution of the United States. But then there's other people, such as Jamie here in the state of New York, that he did get what he thought was an indictment. It says indictment on it, signed by the prosecuting attorney, but yet he didn't have the opportunity to be able to confront those hearsay accusations against him in the proceeding that exists for his protection. And as a result, that prosecuting attorney committed the crime of obstruction of justice because they breached the Title 42, 1981 and denied a person fair and equal benefits of the law in the proceeding. And remember, if government commits a crime to produce an outcome, that outcome is unlawful because government cannot break the law in the pursuit of an outcome. So for those of you out there that maybe did get an indictment, but you weren't present in the grand jury to confront the accusations against you, that's not an indictment. That's an information erroneously called an indictment signed by a prosecuting attorney because they committed a crime in order to secure that indictment. And so you cannot be denied the right to be present in that grand jury. And I understand that that's the way that it works. I understand that what I'm saying is not what they do. What I'm telling you is that what they're doing is unlawful. It's not consistent with what the law demands. So we have an issue of people that are outright being held without an indictment by a grand jury. That's around 700,000 people across the United States of America that never received an indictment by a grand jury at all. But then you have people such as Jamie here who didn't get the opportunity to benefit from the proceeding that exists to protect him from the very person that's now seeking to prosecute him. Right?
Well, there's a little bit more to that, though, if you don't mind.
Yeah.
Well,
I don't want to go into whether or not you were there.
Oh no,
Yeah, okay.
no. But my issue is when I went to the court clerk's office just the other week. If you don't mind me talking about that. Yeah, I went to the court clerk's the other week to see when my indictment was filed because I've been having some issues. And when I asked the clerk this, she just kind of looked at me funny. Now, I was arraigned for this indictment last year in July. I think it was July 12th, 2024. No, I was indicted July 12th, 2024, arraigned August 13th, 2024. Been going to court for what now, 14, 15 months. The court clerk looks at me like I'm nuts and just goes, "What do you mean, what indictment? You don't have one. It left off at HGJ 71736. I go, "Are you kidding me?" No. Did I get something in writing? Something in paper? She wouldn't do nothing. Well, all my lawyer did is he wrote an affirmation. He didn't write any motions. He didn't call anybody, make any calls. He did absolutely nothing. It's going on 3 weeks. And something like that. What do you even do? Like when you find something out like that they don't have anything, because I'm kind of lost.
Well, someone just asked that question. Right? Someone just said the court doesn't care and they'll arrest you anyway. We need to get to the root of the problem. Okay, we are getting to the root of the problem, but we have to do it in kind of some baby steps here. You're right. Just like Jamie and I, we talked about it earlier today, right? And he said, well, what do I do? Do I obey these orders from this court? Do I go into the courtroom and obey them? And a lot of people don't know this, but before our nation's motto was "E pluribus unum," which means out of many comes one, Benjamin Franklin proposed that our nation's motto would be obedience to tyranny is disobedience to God. Right? That was what Benjamin Franklin proposed at the end of the Constitutional Convention for the nation's motto. Obedience to tyranny is disobedience to God. Now you can look at that in the inverse, that obedience to God is disobedience to tyranny. We're not called to obey tyrants, right? If a judge or a court orders you to come in, right, and stand for an offense or something, and yet that court doesn't have the lawful authority to oversee the case, that's an unlawful order, right? It is. It's unlawful order. And if you obey it, now you are obeying a tyrant. But the problem is that I get it, right? You're going to get a warrant issued, right? If you don't show up and obey that tyrant, they're going to issue a warrant. But there comes a point in time when if you're going to claim to be free, you got to act like you're free, right? And we do not have to obey an unlawful order. I mean, you guys are hearing this on the news right now. It's playing out. The Senator Kelly and the whole narco terrorism thing, it's literally playing out in front of us. You don't have to obey an unlawful order, including people, right? If the court orders you to come in, if they summons you, if they order you to come in, but that order is unlawful, you don't have to obey an unlawful order. Now, that's not saying that they're not going to issue a warrant against you, right? That's not saying that they're not going to take action against you. But what I am saying is that, the root issue, the root and the heart of the issue is what I'm litigating here. Can a state be both accuser and judge in the same cause? I'm not arguing indictments. I'm using the indictments as a mechanism to get into argue the root of the issue. Can a state be both accuser and judge in the same cause? The answer is absolutely not, right? The Constitution says so, right? Title 28455, the Automatic Judicial Recusal Code says so. James Madison in Federalist Number 10 says so. Alexander Hamilton in Federalist 80 says so. You know, Martin versus Hunter's Lessee, United States Supreme Court says so. States cannot be both accuser and judge in the same cause, and yet, in Jamie's case here, they are.
And as they say, because I was upset about that one indictment because my daughter was taken away from me. I've seen her 17 times since December 23, 2023. There's nothing showing I've ever hurt my daughter. I've never hurt my daughter. My ex-girlfriend put a family petition in on me on December 26, 2023 to try to file a court order of protection, which she made nothing but false statements in, which has not even been brought up but one time. It hasn't gone to trial or hasn't been anything, but yet they keep on just adding order protection after order protection every time one expires and using that same number and just keep on doing it so I can't see my daughter. Yet she's the one with the mental health, all these issues, but of course they give my daughter to her. But I was, I had a YouTube station. I went on there, and I said some stuff I probably shouldn't have, but I was upset. I couldn't see my daughter. That the courts were messing with me. The judges were screwing with me, and I called the judge some names. But they even said it was my First Amendment right on the reports, this and that. And then, anyways, I ended up getting arrested for terrorist threats, which then all of a sudden they lowered at the grand jury using CPL 180.85, and the only time they can use that is if the grand jury didn't hear the case. It's been sitting around for a year, and the case was only 6 months old. The grand jury heard it, yet they used it, and then gave me aggravated harassment of a judge, where the judge actually wrote the deposition. And this whole charge, this aggravated harassment of a judge, I guess, just came out at the beginning of this year. And from like what he's saying, this charge doesn't make any sense, because how can a judge be a judge and the victim, and then because what were you saying about that? He's more knowledgeable than I am.
So the Constitution of the United States of America, under Article 3, Section 2, and I agree, you guys, this is not how the system works today, right? So I'm not talking about how it works. I'm talking about how it's supposed to work, okay? And this is important because here in a moment, I'm going to want anybody that's had federal charges, right? If you've ever had a federal charge from a federal crime, you need to stick around, because I need you to help me, all right? All you federal cases, right? Anybody that's been convicted or charged with a crime in a federal court, I need you to stick around, please, right? Because I'm going to need your help, and I'm going to explain what I need help with in a moment. So the Constitution of the United States of America, right, is the overarching requirements that every state must follow. No state can enact its own alternative legislation, substitute it for the guarantees of the Constitution, and then go out and enforce that as though that's constitutional. That would be unconstitutional. That's why the 14th Amendment says that no state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens. So the privileges and immunities of United States citizens are at a minimum what the Constitution of the United States of America, limits the government power. The purpose of the Constitution is to establish rights, limit powers. People have rights, government has powers. And those powers are specifically limited in order to preserve the individual rights of the people. So in some cases, the federal government's powers are limited by the Constitution. In other cases, state powers are limited by the Constitution. In more cases, both powers are limited by the Constitution, but they're all limited in order to preserve the individual liberties of the people. That's the intended purpose of our Constitution, to preserve the liberty of the people through a limit of powers of government. And the Constitution was absolutely intended to limit the power of state government. That's why the 10th Amendment even says so. Power is not delegated to central government, nor restricted by the state government. It is reserved by the states' people respectively. That doesn't say that states have unlimited power. It says that certain powers are restricted against the states, which are codified in the Constitution of the United States. That would be the limitation of powers against the states, such as the grand jury indictment. That's a limitation of state. But in order for a court to render a legally binding decision, it must have two things. right? Must have two things. The first thing it must have is it must have subject matter jurisdiction. Subject matter jurisdiction is the right to oversee the type of case that's brought before it. Okay. So, for instance, in the case of a death, you wouldn't bring that case to a small claims court because a small claims court wouldn't have subject matter jurisdiction to oversee the disposition of the deceased assets. You would bring that to a probate court because a probate court would have subject matter jurisdiction. The second thing that a court must have is it must have personal jurisdiction, which is the right to oversee the parties involved in the dispute, right? So if a state if a court lacks either one of those two things, not both, but either one, if they don't have subject matter jurisdiction or if they don't have personal jurisdiction, then that court has no jurisdiction. And that would mean that it has no authority to speak the law. It has no right to enter into judgments or decisions. And anything that it does do is wholly void without force or effect. Refer to Civil Rule 60B4, right? Civil Rule 60B4. What Civil Rule 60B4 says is that a judgment is either valid or it's void. It is valid in all instances except for when the court rendering the decision lacks either subject matter jurisdiction or personal jurisdiction. If the court rendering decision lacks either subject matter jurisdiction or personal jurisdiction, then what it produces is void, without force or effect, as though it never even existed. And no void judgment can ever become valid because no court that lacks jurisdiction can ever obtain jurisdiction. Jurisdiction comes as a first duty to the court. Before the court can be a court, it must have the authority to speak the law. It must have the authority to be a court. And that authority derives from statute. It doesn't derive from a judge saying, oh, yes, I have jurisdiction. It doesn't derive from a state saying, oh, yeah, we have statutory jurisdiction because our laws say we do. We have no. The Constitution grants jurisdiction to different courts, right? The Constitution of the United States of America. And in the Constitution, it has two different jurisdictions for the Supreme Court of the United States. Look it up. United States Supreme Court. This isn't state Supreme Courts because the state Supreme Courts didn't exist at the moment that the Constitution was ratified. It was referring to the Article 3 Supreme Court of the United States, right? Two different jurisdictions of that court. One is original jurisdiction, and the other is appellate jurisdiction, okay? Original jurisdiction, appellate jurisdiction. Now, we are all very familiar with the Supreme Court of the United States appellate jurisdiction because we appeal to that court every single day, right? We believe it's a court of last resort. If we get a bad, unjust decision from a lower court, then we can appeal to the Supreme Court of the United States, asking them to review our case, right? Because they are a court of appellate jurisdiction. But the Constitution of the United States of America, it says, Article 3, Section 2. Guys, go out and read this for yourself because it's right there for all to see. It says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Original jurisdiction means that that's the court to act first. No other court can act before the court of original jurisdiction. So what the Constitution of the United States of America says is that in all cases, criminal, civil, it doesn't matter, all cases in which a state is a party, the Supreme Court has original jurisdiction. That doesn't say in all cases in which a state is the moving party. It doesn't say in all cases in which a state is the responding party. It says in all cases in which a state shall be party, meaning that it doesn't matter which position in the case the state is. If a state is a party in a cause, the state does not have jurisdiction to oversee that cause because original jurisdiction is statutorily imposed, assigned to the Supreme Court of the United States of America. That's a fact. And you have to understand that when you deal with original jurisdiction, that is the authority for the court to speak first. Okay, which means that original jurisdiction is personal jurisdiction. My question to you is, if personal jurisdiction is the right to oversee the parties involved in a dispute, how can the state be judge in its own dispute? If the state is a party to the cause, moving party or responding party, if the state is a party to the cause, how can the state oversee that cause? How can the state have personal jurisdiction over itself? And herein lies the wisdom of the Constitution of the United States of America. This is what the founders were creating there, is that the state cannot be both accuser and judge in the same cause. Because if they are, then that would mean that the state would have bias, prejudice, and interest within one party over another. The state would work together in order to skew the disposition about legal proceedings so that they could win the case. So a state is made up of a body of men, right? Just like I'm a body, right, with a whole bunch of parts. I have hands and eyes and ears and legs and all these different parts of my body, right? A state is also a body. It's a body of men with prosecutors and judges and law enforcement and CPS, all these different parts of the body of the state. If any one of those agents of the state brings an accusation against you, then the same body of men that represent the state cannot be judged against you, right? And thus, when a state becomes a party in the cause through any one of its agents, be it a prosecuting attorney, law enforcement, a judge, CPS, the state cannot be presumed to be neutral and biased to act as a judge against you, and they are thereby discharged from being able to oversee that, because personal jurisdiction is statutorily removed. Now,
so it would have to go federal then, right?
That's the way it's supposed to work. Yeah. If the state brings the accusation, the state can't oversee it, which means that the federal court must be the judge. That's why the Constitution says in all cases in which a state shall be party, the federal court has jurisdiction. The Supreme Court has jurisdiction. If the federal government brings an accusation against you, the federal government can't be judged against you for this exact same reason. That's why the state becomes the judge in a case in which the state or the federal government becomes the accuser. That's the way that the system was designed to work, right? That's the way the Constitution was written, and that creates a separation of powers so that the judge is not part of the government that's seeking the enslavement, imprisonment, or the establishment of laws. Today, what's happening is that you have the state that determines what is or is not criminal behavior. You have the state that investigates whether or not you've committed criminal behavior. You have the state that charges you for a criminal act. We have the state that judges you as to whether or not you're guilty of that criminal behavior, and then the state that profits off your forced involuntary servitude once they've deemed you a criminal. There is no neutral, unbiased arbiter in that process, and that's what the founders of the Constitution here in America were trying to prevent. We needed a fair, neutral, third-party decision maker to oversee the state's accusations and allegations to make sure that the state is not exceeding the power, authority, statutory conferred upon them. The judge must be a separate governmental entity than the one creating the laws. Now, a lot of people would say, well, you're interpreting this wrong. I'm not interpreting it wrong, but let's go ahead and dig in a little bit more, right? And we got to go here in a moment because we have kids that are going to be going to sleep here in a few minutes. But let me get through this article 3 issue, this original jurisdiction issue. Okay. So if we want to know the rationale behind the Constitution of the United States of America, why did our founders write the provisions the way that they did? We would typically go to the Federalist Papers, right? That was written by John Jay, Alexander Hamilton, and James Madison. Those three people wrote the Federalist Papers. Now, even according to Justice Gorsuch of the United States Supreme Court today, he says that all things Constitution and the origins of the Constitution comes from James Madison. He was considered the father of the Constitution. He wrote the Bill of Rights. He wrote the Virginia Plan. He wrote most of the Constitution, right? James Madison was the father of the Constitution. So what did James Madison have to say about Article 3, Section 2? In all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Well, James Madison wrote the Federalist number 10. This was New York Packet, November 23rd, 1787. The article was titled "The Union as a Safeguard Against Domestic Faction and Insurrection." And in that article, what James Madison said was, no man is allowed to be judged in his own cause because his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time. So now we have the founding father, right? The father of the Constitution wrote in the Federalist Papers the reason why Article 3 says a state cannot be both accuser and judge is because no man is allowed to be judge in their own cause, because their interest would bias their judgment and corrupt their integrity. Therefore, a body of men are unfit to be both judge and party at the same time. The state cannot be both accuser and judge because James Madison said, no, it would create bias, conflict of interest, right? So now we've got one of the founding fathers, one of the drafters of the Constitution, the father of it, the one that wrote the Bill of Rights, and the Federalist Papers. We've got them pointing to the fact that a state cannot be both accuser and judge in the same cause. Maybe that's not enough. Maybe we need some more, right? So now let's take a look at the next drafter of the Federalist Papers, which was Alexander Hamilton, who was also one of the main drafters of the Constitution, part of the Constitutional Convention, one of our founding fathers. What did James Madison say about this issue? Can a state be both accuser and judge in the same cause? Well, we would find the answer in the Federalist number 80. Alexander Hamilton wrote the Federalist number 80. And what he said, he made two different statements within the Federalist number 80 attesting to this issue. The first thing he said is he said the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. All right. So again, the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. So the federal judicial authority of the Union means the federal judicial system. The federal judicial authority of the Union must extend to all cases between a state and the citizens thereof, or the citizens of that state. So if there is a dispute between a state and the citizens of that state, the federal judicial authority must extend. So that's the first part, right? That's the first part of the Federalist number 80 that Alexander Hamilton was attesting to, saying states cannot be both accuser and judge in the same cause. Now, the second part that he said was rules must not conflict. No. He said,
Well, let me stop you there.
Go ahead.
What do you think? Because I just want to bring up, why it's so important that, he's doing what he's doing. Do you know that when I was helping my lawyer with a motion, because the guy's a moron, but I was actually doing a motion, and he's telling me, well, what's the case law for this? What's the case law for this? I go, why can't we just use, the Bill of Rights, or our CPL number or stuff like that? No, you have to have the case law in there. The case law is just it's a ruling that a judge made up that just goes over our rights. And they're making all these laws themselves. They're doing pretty much what they want to do, and these are what we have to go by. I don't think that's right. I think our rights are our rights, and they should be going by the Bill of Rights. I think when you do write a motion, I think case law should be the last thing you ever put on, because really any judge can just say, well, that's the law. It's flip-flopped. Our rights should be the number one. The Bill of Rights should be number one. And that's why this is important, what they're doing. We were talking today. Like I said earlier, we're talking about how my story's important. It's not. Everyone's story is important, but the thing is without jurisdiction, attacking that, once that happens, it's like cutting down the whole apple tree. They all fall instead of picking one at a time.
So Alexander Hamilton, what he said in the Federalist number 80, the second part was, he said state tribunals cannot be presumed to be impartial when they speak for themselves. No man ought certainly be a judge in his own cause or in any cause with which he has the least bit bias or interest. Okay, so again, this is pointing to conflict of interest. But he specifically says state tribunals cannot be presumed to be impartial when they speak for themselves. No man ought certainly be a judge in his own cause or in any cause with which he has the least bit bias or interest. So he first said that The federal judicial authority of the union must extend all cases between a state and the citizens thereof. So if there's a dispute between a state and those citizens, then the federal court must extend, pointing to Article 3. The state can't be both accuser and judge of the same cause, right? And then he goes on to say state tribunals cannot be impartial when they speak for themselves. Therefore, the state cannot be presumed to be impartial when the state itself is the party, right? And so this body of men that make up the state cannot be presumed to be impartial to speak for themselves if the state itself is a party to the cause.
So
if the state brings the laws against you, the state cannot be judged against you. So there's the first two framers of the Constitution, two of the drafters of the Federalist Papers, two of the drafters of the Constitution, and now we have a third author of those papers, which was John Jay. Now, John Jay was sick during the period of time that the Federalist Papers was being written, and so he didn't write very many of them. We don't have writing from John Jay in the Federalist Papers that attests to this issue. But he did become the first United States Supreme Court Chief Justice. And he did make a statement attesting to this in a case called Martin versus Hunter's Lessee. Okay. So in the ruling, Martin versus Hunter's Lessee, what they said, Supreme Court of the United States, what it said was that the Constitution has presumed that state prejudices, state biases, and state interests might from time to time obstruct the administration of justice by state judges. Therefore, it is the case and not the court that grants original jurisdiction to the Supreme Court. Again, it is the case and not the court. So when the state says to you, or the Supreme Court of the United States says, oh, you have to get a judge, you have to get a decision from the lower court before you can bring it to the Supreme Court. You guys hear that every day, right? You guys got to get a decision from the lower court before you can bring it to the Supreme Court, and they tell you that that's what you have to do. But it is not the court that grants jurisdiction. It is the case that grants jurisdiction, because the Constitution says in all cases in which the state shall be party. It doesn't say in all cases in which the lower court has made a decision. It doesn't say in all cases that has been resolved in state court, Supreme Court has written. It says in all cases the Supreme Court has original jurisdiction. So we have all three of the drafters of the Federalist Papers talking about the fact that the state cannot be both accuser and judge of the same cause. We have Supreme Court precedent, rulings in place that says that the state can't be both accuser and judge, and that the Supreme Court must be the court of original jurisdiction because the Constitution assigns it. We have the Constitution itself, right? We have the words of the founders and framers of the Constitution written in the Federalist Papers. But now this brings me to my point also, is that Title 28 USC subsection 455. 455 is the automatic judicial recusal code. Okay. Title 28 is all the judicial code. 455, that's 455, is the automatic recusal code. If you guys were to go out and read the automatic recusal code, I'm going to tell you it's changed recently, right? A couple years ago, it didn't say judges of the United States. But today, when you go out and read it, because I just went out and read it this afternoon, it's been changed. So they've amended it, and they said that judges of the United States, which would be federal judges, district court judges, magistrates, appellate court judges, judges of the United States. So the automatic recusal, according to the statute, only affects federal judges, which isn't true. We'll argue that later. But my point is I want all of you, and I want you to spread this information. You tell everybody that you know, if you have had a federal charge or a federal conviction, I need these people to take action. I need them to hear what I'm about to say. Because when you go into the judicial recusal code, it says that a judge has a mandatory, non-waivable, self-executing duty to recuse themselves if, go down to item 5, subsection I, if they are an officer of either party. Guys, go out to LII right now, right? Go to LII, pull up Title 28, subsection 455, go down and read it, And what it says is that if you are an officer of either party, you have an automatic, mandatory, non-waivable, self-executing duty to recuse yourself because of the obvious conflict of interest that happens. So these are judicial officers of the United States who just so happens to be the moving party in all these federal cases. Every single federal judge has an automatic, mandatory, non-waivable, self-executing duty to recuse themselves because they work as a judicial officer of the plaintiff. And thus, these judges are all acting when they don't have jurisdiction in these federal cases, right? I'm going to do a video, and we're going to do like a 3-minute video and get it out there because I need this information to spread, because I need these federal criminals, these federal convicts. I need them to step up and start doing motions to vacate for lack of personal jurisdiction. That's what you got to do. You need to do a motion to vacate for lack of personal jurisdiction. The judges of the United States, if they have a mandatory, non-waivable, self-executing duty to recuse themselves under Title 28, subsection 455, then that means that they did not have personal jurisdiction to oversee that case, right? They didn't have personal jurisdiction. And if the judge acts when he lacks personal jurisdiction, the authority to oversee the parties involved in the dispute, because the law says that he must recuse because he's an officer of either party, then that means that whatever that court did is void, wholly without force or effect on the parties involved in the dispute. State cases is what we're still working, okay? The state judges are claiming that 455 doesn't apply to them. We're going to overcome that, but I need to start seeing some action, right? I'm tired of sitting around. I'm tired of getting beat by these guys. I'm tired of the bullshit from them. I need help. We got to take action. And the action that we have absolutely under law is not one single federal judge can oversee a federal case because Title 28, 455 removes personal jurisdiction from them. Every single federal prisoner right now today could file a motion to vacate judgment for lack of personal jurisdiction, pointing to Title 28, subsection 455 and saying, this judge who oversaw this case had an automatic recusal. And according to Hill versus Weeks, United States Supreme Court, according to Cohen versus Virginia, United States Supreme Court, anytime that a judge takes action in a case that they have an automatic recusal, that judge is now warring against the Constitution and committing the crime of treason, right? That's already settled. That's already in place. So we have a very, very significant situation where every single federal prisoner, we could take action right now with a motion to vacate submitted to the court that initiated it and say that judge did not have the constituted authority to be able to oversee the case because they had an automatic recusal under law. And we need to do this before they change the law once again, because that's what they're doing. They're hearing what we're saying, they're listening to me, and then they're going out and they're changing the law. They're amending the law. We need to do this, and we need to do this quick, right? Every single federal prisoner, every single federal charge, they can file a motion to vacate judgment or vacate charge based upon the lack of personal jurisdiction. And under the law right now today, that court would have no choice because of the obvious conflict of interest and the automatic judicial recusal that's in place. We need some action. I need to start seeing something happening. I'm tired of getting beat here, and we need to start doing something. So I would like to get these federal employees or these federal prisoners to step up, take action. We do a massive push toward the automatic recusal, relying upon the code, the judicial recusal code, and let's start bringing some attention to this issue. All right. I know that we're not going to get the outcome that we're looking for, but the more pressure we can put onto the judiciary, the better, right? And right now today, there isn't a single federal judge that can oversee a federal case because they're an officer of either party. Officer of the United States of America, a judicial officer of the United States, which just so happens to be the moving party. This is a very, very simple thing, all right? So we want to get these motions to vacate, motions to dismiss based upon absence of personal jurisdiction, and we want these federal prisoners and these federal defendants to get these moving through the court, right? This will slam the federal court and slam the judiciary, and they won't have a lawful response to it. These are judicial officers of either party. And according to Title 28455, that is not an automatic recusal. We are going to have the same argument for the states, but right now, because they've changed the law, we can't rely upon the law as the mechanism to say, oh, well, the state judges have to recuse because unfortunately Title 28 has been amended to remove state. It says only federal, this only affects federal judges of the United States of America. We know that that's bullshit. But nonetheless, on the state courts, we still have the Constitution that clarifies in all cases which a state shall be party. Supreme Court has original jurisdiction. We have the constitutional provision written right there that we are relying upon by the state. But the problem is that we're not getting action, and I'm tired of not seeing action. It's time for us to do something. It's time for us to get motivated, and work together to slam this court with what's necessary to overcome this. So I'm going to do a video, and I would hope that you guys will share this video and help spread this. And we're going to keep it short. We're going to try to do it under 3 minutes. Jessica's going to be working on it, and it's going to be explaining to you guys with the automatic recusal code and asking the federal prisoners to please step up, get a motion to dismiss. I will probably draft the motion, kind of like the affidavit. We'll get it out of the website. It'll be one single motion in a standard form, and it will be again a motion to vacate or a motion to dismiss. Right? If you've been charged with a crime but you have been committed, it would be a motion to dismiss for lack of personal jurisdiction. If you have a conviction, it would be a motion to vacate for lack of personal jurisdiction. If the judge that rendered the decision in your case did not have the jurisdiction to oversee the case because they had an automatic recusal, then that means that what that judge produced is void, without jurisdiction, without force or effect under Civil Rule 60b-4. So we'll get this drafted. We'll get it out on the website. It's not coming from me. Well, it is coming from me, but you guys are going to have to submit it because I'm not your attorney. You're going to have to act as your own attorney in active litigation against the United States of America. So we'll try to get this done as quickly as possible. We'll get it out on the website. It'll be, again, a motion to vacate or a motion to dismiss. And we need the federal people, federal charges and federal convictions to step up and help move this along, right? We need this really, really bad right now, right? Because I'm tired of getting beat. We've got to make something happen. So the root cause of the issue, or the root issue, is, can a state be both accuser and judge in the same cause? No. Okay. Can the United States of America be both accuser and judge in the same cause? No, they can't. Right? Which is why when a state brings an accusation against you, the United States of America, the federal judicial authority, must be in charge. When the United States of America brings an accusation, then the state must be the judge. And therein lies the separation of powers and the wisdom of the Constitution of what our founders actually created. The United States of America cannot be judge of its own case. The state cannot be judge of its own case. So we have a separate judiciary that would be able to act as the judge in opposing situations. If the state chooses to create its own laws, that's fine. But that means that the state cannot be judge of its own crimes. And now the federal judicial authority must extend. The United States of America creates laws, that's fine. The United States of America can't be judge in its own case, and now the state takes over. And that's also codified in Article 3. So West Virginia, someone wrote something about West Virginia earlier. We're in West Virginia this weekend. All right, so we'll be in West Virginia for in Charleston for the family senatorial event this Sunday. So some senators are getting together for some family court issues. We're coming down there. We'll be there in West Virginia, Charleston on Sunday to support you guys there. And so we hope to see you guys come out. Again, we're also in Tennessee next week. Jessica's got her case. So if you guys are coming out of Tennessee, love to see you guys there. We'll be there on Tuesday, actually Monday night, but we'll be there on Tuesday. So hope to see you guys there. We're not sure exactly where we're going after that. We've got some ideas. We're kind of thinking West Virginia, Arkansas, because there's some cases there that have been pushing the absence of indictment by grand jury. So we're not sure, but nonetheless, we're heading back into the south and getting out of the northeast here. I'm feeling a lot better. Shoulder still is painful. Still have a little bit of piercing in my side here, but I'm feeling a lot better. So thank you guys so much. PayPal. Some people like DWG, you asked if I got your PayPal. I did. Thank you so much. I appreciate that. I appreciate all of you guys. Again, if you guys want to donate, please don't be offended by what I'm saying, but please don't be stupid. All right, because there's a lot of fake accounts out there that are pretending to be us and they're not us, right? They're pretending to be Jessica, they're pretending to be me, they're not us. And they're asking you guys for money and they're getting thousands and thousands of dollars from you guys. Oh, they did to you? Yeah, they're getting thousands of dollars from you guys. And so, but Jessica actually showed me a picture because someone pretending to be her came out and created a license, right? And so now this person is saying, "Oh, this is me, and here I'm going to send you a picture of my driver's license to prove that it's me." And it's her. It's a picture of her in a Washington State driver's license. But the problem is, you guys, I looked at this picture. Now, first off, I got to say, how many people say, "Oh, I'm going to send you a copy of my driver's license by email just to prove that it's me," right? That's number one, red flag. All of you should be going, "Wait a second now, that doesn't make any sense." Nobody sends a copy of their driver's license to prove that it's them. And if they do, if that's what they offer up to you, then guys, you gotta be a little smarter than this. Don't donate to someone that sends you a copy of a driver's license. But when I looked at this picture of this driver's license, did you know that it said that she was 6'5", 180 pounds? She's not 6'5", she's 5'2", right? 100 pounds. But this said 6'5", 180 pounds. The address was 15 Washington D.C., and then it said Washington State. Guys, be smart here, okay? If someone messages you asking you for money, pretending to be us, guys, we don't reach out to you. We don't ask you for money. This is how we do it. If you want to donate, we would welcome those blessings, but please be smart about it. If someone messages you asking you for money, it's not coming from us because that's not what we do. We don't do that. But if you want to donate, we will welcome those donations because we still need them. We operate based upon the generosity of all of you. You guys believe in what we're doing, and we continue to do it because we love what we're doing. We believe in it. And as long as you guys believe in us, then you guys are the reason why we're able to continue to do these things. All right. But
where's the best place for them to go to do that?
Best place, website, justicewithoutlimits.org, right? That's going to be what we're in control of. You can go to justwithoutlimits.org and there will be the donation points there. You guys, if you have any question whatsoever, that's the best way to do it. That's the surest way to make sure that you're giving it to the right source. But you can also give it to my Cash App, Chime, Venmo, PayPal, which is all what you will get when you go out to Just Without Limits. If you go to justwithoutlimits.org, it is still these particular sources, but what you do is you click on it and it will take you to my Cash App or my Venmo or my PayPal. We only have Cash App, Chime, Venmo, PayPal, and Zelle, right? And they're all exactly the same, right? This is the We Shall Be Free tour. Therefore, the source is We Shall Be Free. If you guys want to donate, that's where you guys donate to. Okay, We Shall Be Free. Or if you or Zelle, it would be Justice Without Limits. Okay, but nonetheless, go to the website. Don't be bamboozled. Don't get scammed, please. And if you guys do, please don't blame us because we're not scamming you. We're out here doing what we know is the right thing to do every single day. We're responsibly spending your money and using every single cent that you guys donate to us to deliver on this promise that I made to all of you that I know we're going to be able to deliver. So thank you so much, DWG, for the donation. We'll be back up in Massachusetts before too long. Look forward to connecting with you. I also want to say I watched the Alabama Solution the other day. Oh my God. Alabama brothers, sisters down there. I don't even know what to say. It is, God. Last year when that young man was killed, 23-year-old white male was killed, and he was sent back to his family without the heart. God has this tendency of making me know things ahead of time so that I'm less shocked when that time comes, right? So that I'm not as shocked to learn things. But When I first read that story, right, the news story about that young man who went back home, I believe in Michigan, and he was missing his heart. Uh, the first thing that God put into my heart, in my mind, was how much will a billionaire pay for a new heart, right? Alabama Department of Corrections, how much will a billionaire pay for a new heart? And the scary thing is that there were thousands of people killed last year in Alabama prisons. Just in that alone, across the whole country, I don't know how many thousands of people, but there could have been 10,000 people killed in our prison system across the whole country last year. Those 10,000 people, the majority of them are either cremated or just buried out back because they come from poor families. Those families don't have the money to be able to bring them back, and certainly not have the money to be able to do autopsies on them or whatever. We don't know the condition of those bodies. We don't know what happened to those individuals because there's no outside investigation. But what we do know is that we have actual tangible instances of these prisoners that were killed who were young, who were healthy, and who were coming back without their organs. And so the question I have is, how much will a billionaire pay for new organs? Because these prisons, they have DNA on these prisoners. They have blood work on these prisoners. They have the medical conditions and all the rest, and they have complete and total control of these prisoners along with all of their medical and DNA data.
It's like shopping at Walmart, pretty much. Know what you want. Here's all the information. Which one?
So all that I can say is, if this is what our justice system is doing, all right, if those people are there for that purpose, then God help us. I mean, God help us. Because if that's true, then this is the most evil institution that I think could ever be conceived.
You mind if I say something?
Yeah, go for it.
Yeah, because I'm in Rochester, New York, Monroe County, and recently there was just there was something online and talking about missing eyeballs over at the what is it where do you after you die where do you go whatever the person is. Yeah, so they were missing eyeballs here in Monroe County. Is this going on everywhere? I mean, it just seems there's a lot of sick stuff going on these days, and it just seems like it's good against evil. This is the good. Judicial is the evil.
Yeah.
We got to open our eyes. We got to lift that veil.
Yeah.
We got to see the truth. When before I always used to think, I always had my doubts about police, but I thought the courts, the judges, no matter what, if you're innocent, they're going to do the right thing. Nope, but you got to live it to realize, no, they're not going to. Cops, judges, DAs, clerks, paid attorneys, all of them. They don't care about you, him, me, anyone. You know what they care about?
Yeah.
Benjamin and themselves.
We got to remember that crime makes them and their institution a lot of money. They're not in the business of morality, right? They're not in the business of helping people be better. They're in the business of causing trauma, starting from the destruction of the familial unit and the removal of children. Because once again, you cannot deny the link between the CPS system and mass incarceration. You cannot separate those two things. You can't do it. Because for every child that you remove from the love and care of mother and father, right? Either or, that child grows up and then becomes an adult that has an 80% likelihood to go into prison over their lifetime. So we talk about Title 4D, Title 4E, we talk about that. And we say, look, here's the financial incentive. The state is financially benefiting off of, the removal of this child through the Title 40 and Title 4E. But you guys, that's drops in the bucket, right? We're not talking about the long-term financial interests of the state, because for every child that they do that to, yes, there is an initial financial incentive. Yes, the state is absolutely getting paid to destroy the family. Therefore, they have vested financial interest in the outcome of that dispute. No denying that. But the long-term effect is what we're not talking about. And that's what I keep on trying to bring up to all of you, is that this is why I have so much compassion for prisoners, is because every single prisoner is someone's child. I don't care if that child's 50 years old or 2 years old, they're someone's child. And that child was once, or that adult was once a child, a young child, who had something happen to them that tragically changed the trajectory of their life. And now they're in an institution because of what happened to them, right? They're not getting healed, they're not being helped. And now that state is absolutely every single year benefiting financially, not only from federal grants paying for the imprisonment, but also the forced involuntary servitude of that individual in a for-profit business that directly benefits the state, because the states are able to take people, make them a criminal, and then force them into involuntary servitude so that they can benefit financially off of the labor that they extract from them in this slavery institution. I mean, we have to be honest about this. We have to acknowledge the link between family court, the destruction of the familial unit, the removal of a child, and mass incarceration. You cannot deny the correlation between those two things. You can't. So what we have to remember is that there is 12 million children right now today that have been removed from their families by CPS across the country. 12 million children. Okay, 12 million children in federal custody or in state custody removed. That means that statistically 10 million of them are going to end up feeding into this incarceration system within the next generation. 10 million. Today, right now, as we speak, there is 2.9 million prisoners across America. 2.9 million prisoners. We have 16 times more prisoners than the next closest industrialized nation at 2.9 million. We have had an 800% increase in the prison population in the last 30 years, right? We imprison at a rate of 16 times more than the next closest industrialized nation at 2.9 million prisoners, right? 2.9 million. But take a look at one single generation, what we're looking at here. One generation. In the next 20 years, we could have 10 million more prisoners feeding into this system because of the trauma that these states are inflicting upon your children. Your children that they've taken from your love and your care, your custody, placed into the state custody. 12 million of them, statistically 10 of them, are going to end up in prison. Your children are going to be forced into involuntary servitude and punished for something that was not their fault. These children are being hurt by the state so that they can profit off them financially, initially through Title 40 and Title 48, but long-term through the imprisonment enslavement system that we have in place. It's known as incarceration. You have to acknowledge the correlation between the two. I want all children back home. I don't care how old they are. I want every single child that's been abused and hurt by this system. I want them back home, getting the love and care that they need so that they can heal from the traumatic experiences that this system has inflicted upon them unconstitutionally and illegally. That's what I want. That's my dream. That's my vision. That's what I've told you guys I want. And I don't care how old those children are. I don't care whether they are in a prison and state custody or they are a child in state custody. I want them to get what they need to be able to heal from the traumatic experiences that has happened to them. And that's where I'm going with this.
If the CPS comes to your house, do you have to let them in?
So if they have a warrant, then that could be.
If they don't have a warrant, so they come knocking on.
No, you don't have to.
You
No.
don't let them
in. No, you don't have to. You don't have to work with them. Nothing. Yeah. So, remember on the CPS side, right? On the CPS side and the family side, we can't fight this case the same as we can with the grand jury, right? And you guys, you really need to understand this, okay? The right to have an intimate relationship with your child was found to exist by the Supreme Court of the United States in 1984, a case called Roberts versus United States, okay? So you have the right to have an intimate familial relationship with your child without government interference and your child has the right to have an intimate familial relationship with you without governmental interference. That was found to exist by the Supreme Court in 1984, Roberts versus United States. It's the right of intimate association. So you have the right to have intimate association. Now, that being said, okay, I understand that there's instances that we probably need to protect children from abusive parents, right? I get that. I totally understand that. I'm not saying that there's not instances that we need to help children. But what I am saying is that until we determine those very specific instances, no state can create a law that interferes with your relationship with your child as long as it's fundamental protected by the Constitution of the United States of America. If a state could create its own law that interferes with your relationship with your child, that would be unconstitutional, because the Supreme Court said you have the right to have an intimate familial relationship with your child without government interference. You have the right to have a relationship protected by the First and 14th Amendment because it's a creation of God. Your child came from God. God made you a mother or God made you a father. Only God can take that away. The state can't do it. Therefore, the state can't interfere with it because it's a creation of God, not a creation of a state. This is the whole rationale behind the Supreme Court's decision in 1984. But I get it. I get that there's instances that we want to. But until we have determined those instances and written it in law, no state can interfere with the fundamental right of intimate association with your children, because it would be unconstitutional. If the Constitution protects the right, no state can create its own alternative legislation, substitute it for the guarantees of the Constitution, and then go out and enforce that as though that's constitutional. Supreme Court of the United States determined that your right to your relationship with your child is protected by the First and the 14th Amendment, found to be fundamental, which is very, very important. Fundamental constitutional rights are very, very important. Found to be fundamental, and therefore no state can interfere with it, because states can never interfere with fundamental constitutional rights. But the problem is this, is that the Supreme Court found that it exists, right, as a right, but that's an incorporated right. It's not enumerated. If you open up the Constitution right now to the First Amendment, nowhere in it does it say you have the right to have a relationship with your child. You go to the 14th Amendment, nowhere in it does it say you have the right to have a relationship with your child. Because the court found that it exists, they determined, they incorporated, they created the right, right? And they said that this is now, it exists. We found that it exists. But it's not within the Constitution. So we can't go to the Supreme Court and say, we have the right to intimate association because the Supreme Court said so, because it's not written in law. This would counteract our whole argument. The judicial branch doesn't create law, right? Law must be created by the legislative branch. So if we went in, we said, oh yeah, well, this judge-made ruling from 1984 says that we have the right, now we would be counteracting our argument of the judicial branch can't create law, because we'd be going in and saying, well, here's judge-made ruling and it's the law. That's why we had to attach to a enumerated right, one that's written in the Constitution. And that's why the grand jury is the one that we settled on. The grand jury is written. Clause 1 of Amendment 5, it's written right there. We can all see it. It's not just found to exist, it's written, right? It's part of the trust, right? Embedded in the Constitution. Therefore, the states can't overstep the restriction power that it has. So when we bring up an enumerated right and we say, hey, this has been abridged, then we would argue that much differently than we would if it were incorporated. But the reason why I bring it up, right? The reason why I'm linking these two together, the way that I'm able to do it is this. When you're charged by information, right, which is an accusation from a prosecutor or law enforcement, right? They're not the victim. It's not a person. It's a government entity, right, or a government agent that is bringing an accusation against you. When you're charged by information, what happens is it creates an irrebuttable presumption of guilt. An irrebuttable presumption of guilt is the presumption that you are guilty based upon the mere fact of having been accused of committing crime. So if the judge presumes that you're guilty because one of the state's agents accused you of committing a crime, that is known as an irrebuttable presumption of guilt. You then have to go out and collect evidence in order to prove that you're innocent, because they're already treating you as though you're guilty. They're taking you and arresting you, putting you into jail. Your rights are taken away, your freedoms, your ability to use your property to generate revenue, to earn, to take care of your family. All these things are taken away because the judge has presumed that you're guilty because one of the state agents accused you of having committed a crime. This is an irrebuttable presumption of guilt. And what happens here is the burden of proof shifts from the prosecutor of the state onto the defendant. Normally, the state has to prove that you're guilty beyond a reasonable doubt. That's the burden of proof by the state. But now the burden of proof is shifted onto the defendant, and the defendant actually has to go out and collect evidence to prove that they're innocent. And this is a shift in the burden of proof. Anytime that there is an irrebuttable presumption of guilt, there is always a shift in the burden of proof. And you can never have a shift in the burden of proof. You can never put the burden onto the defendant to have to prove that they're innocent because the system is already arrayed against them. That would be unconstitutional. So it is a breakdown due process anytime that the defendant has to prove that they're innocent and the state doesn't have to prove that you're guilty. That shift in the burden of proof is a breakdown due process, according to Blackstone, that occurs when the system focuses on speed and efficiency as opposed to the established procedures and processes of law. So it's a breakdown due process anytime that you are presumed guilty based upon the mere fact of having been committed a crime, because the starting point must be you're innocent until proven guilty. That's in a criminal court. In family court, the judge is acting in the exact same way because the judge is assuming that you are unfit to be a parent based upon an accusation brought by a state agent. CPS is saying that person's not fit to be a parent, right? And now the judge presumes that you're unfit based upon an information or accusation of being unfit. The behavior of the judiciary in family court is the exact same behavior of the judiciary in criminal court. I can show that it's a breakdown due process in criminal court, and as a result, we will be able to show that it will also be a breakdown due process in family court. If the judge is acting the same way and presuming that you're guilty based upon the mere fact of being accused of committing a crime, then it must be the same breakdown due process when a judge in family court presumes that you're unfit to be a parent based upon the accusation of an agent accusing you of being unfit. So it's the same breakdown due process, and we can fight them together.
Yeah, real quick. So if they're doing a motion for family court, it's like we were talking earlier, and I was telling you I was putting like CPL in there, case law, and Bill of Rights. You told me I shouldn't be putting the case law in there because it would, then I'm messing up my Bill of Rights. Stick with the Constitution, the Bill of Rights, and what law and like that, correct?
Yeah. So again, like last week in the live, I mentioned that my degree is in substantive law. I'm in law enforcement, right? I'm not an attorney. Attorneys deal with adjective law. Everything an attorney learns is all the laws that remove freedom, because attorneys are in the business of removing freedom. They're in the business of making a person a criminal. That's what they're trained to do. They learn adjective law, the adjudication of law. So everything that an attorney learns in law school is all the laws that remove freedom. Ordinances, statutes, customs, judge-made rulings, all these laws that take away freedom is what attorneys learn in law school. I went to law school, but I went to substantive law school. I learned how to be law enforcement, right? And as law enforcement, I only learned the laws that set free. That's why I'm an advocate. I'm not an attorney, right? And an advocate is one who speaks on behalf of others. An attorney is one who acts on behalf of others. So when you give an attorney a power of attorney, he's acting on your behalf, making decisions for you and all these other things because you gave him power of attorney. So an attorney acts on behalf of others. I, as an advocate, speak on behalf of others. I am trained in substantive law. They are trained in adjective law. I do law enforcement. They do law administration, right? So I do the first part. They do the second part. I deal with building cases and criminals and criminal. That's why everything I am about is criminality. And my point is that, again, I went to the most expensive university in the United States for my first master's. I had got a 3.98 GPA. I graduated in South Lawn, the White House. I know substantive law as well as anybody in this country, right? I know the Constitution as well as anybody because that's what I studied. That was what my degree was in, was the Constitution. So if I could give you $200,000 worth of my education into one sentence, it would be anything that is not the Constitution is unconstitutional. Okay? Now let that sink in for a moment. Anything that is not the Constitution is unconstitutional simply by virtue of the fact that it's not the Constitution. Anything that's not the Constitution would be unconstitutional simply by the fact that it's not the Constitution. So if you want to present a counter argument or a constitutional argument, don't use anything but the Constitution, right? Because anything that's not the Constitution is unconstitutional by the very fact that it is not the Constitution. You don't need to use the UCC because the Constitution is the law, right? UCC is unconstitutional because it's not the Constitution. You don't need to use judge-made rulings, not even Supreme Court rulings, because that's all not the Constitution. You don't need to use state statutes or state constitution or U.S. code. You use the Constitution and you speak the words that it says, because anything that's not that is unconstitutional. So when you go into the court, or if you want to do a motion to dismiss or motion to vacate, like I'm going to write a motion to vacate for lack of personal jurisdiction, I'm not going to put in there case law, right? Because case law is not law. I'm not going to put in there, state constitution. I'm not going to put in there UCC. The only thing you're going to see in there is the Constitution and the United States Code that supports that constitutional provision, such as judges cannot be both accused and judge in the same cause, the whole automatic recusal. Because if you mucky the water up and you go into case law or judge-made rulings and you start citing judge-made rulings, what you're doing is you're actually coming down off your strategically advantageous position. The Constitution puts you into a position that they can't fight at. A good example is for those of you who have done an appeal. When you write your appeal, you'll put in there constitutional law, right? Directly out of the Constitution. You'll put in there United States Code. You'll put in there case law and all the rest. But when you get a response back from the court, every single thing that they cite will be judge-made rulings. They will never cite positive law created by the people. They will never cite actual United States Code, and they certainly will never cite Constitution. Never. Because the court doesn't rely upon positive law created by the people to make their decisions. They rely upon judge-made rulings because they believe that here in America, judges make the law, which is completely contrary to what we believe. Completely contrary to what the Constitution provided, and that's exactly what we're fighting here. So what I'm doing is Chevron last year, June 29th of last year, we got Chevron. Chevron is all about removing all the bullshit that the executive branch put into place. All that policy that they wrote because they said that the law wasn't clear, it was ambiguous, all that bullshit that the executive branch wrote, Chevron is going to remove it. But if we want the Constitution back at the foundation, right, if we want to get it back into its rightful place, then we have to remove all the bullshit that the judicial branch created now, right? Because right now, the judicial branch believes that its judge-made rulings is the foundation. So we want to get the Constitution back to the foundation. What we have to do now is we have to remove all the bullshit that the judicial branch created, that they erroneously and unconstitutionally called law. That's not law because we did not give the judicial branch the right to legislate. We need to remove all of it. And when we do, we'll see the Constitution fall back to the foundation. And now we will be in a world that's predictable and understandable, that's based upon the rule of law. And that's what we're trying to do here. That's what this litigation is all about. That's what I'm trying to do is I want you guys to understand that what I believe in is the Constitution of the United States of America. I believe in its power. I believe in its supremacy. I believe in the words that it says. And I believe that when we have faith in it and we speak the words that it says, we can save this country. Because the only thing that makes America America is that Constitution. If we cannot stand for it, if we can't support it, if we can't defend it, and if we can't believe in it, then we have lost America because nothing else makes America America except for that Constitution. America was established based upon the Constitution. And so when we take the Constitution and we throw it to the side smugly, like these attorney generals across the country are doing, right, in order to promote and progress their own state statutes as superior, we're destroying the United States of America, and we don't want to do that. So what I believe in, right? My faith is in this country, the United States of America. It's not in Washington. It's not in the Texas. It is in America. And what makes America America is that Constitution. So I want all of us to just understand that's what we fight for. That's what we fight from. We can speak its words. We can believe in it, the power, supremacy of it. And when we do, all of this other stuff, right? What Jamie was saying there, all of these inferior laws, they fall away because they have no power against the Constitution of the United States as long as we stick with it.
We need to bring it back.
Bring it back.
We the people.
Yeah. So we have a couple kids here in the house, and we need to go and let them get some sleep. It's getting late here. So I want to thank you guys so much for listening to us talk tonight. Thank you to my friend Jamie here. Thank you, Jamie here, and it was. I mean, it's an honor to be able to go around the country and meet all of you, and you guys invite us in, and we get the opportunity to be able to meet you. And I've got a brand new friend here with Jamie and Kim and Stephanie. So I want to say thank you guys so much, and we look forward to seeing you guys out there in the field. When we come your way, we're not going to stop until this is done. So again, thank you guys so much. God bless, and have a great rest of your night. Okay, thank you.